Hello, everyone, and welcome to our second session wherein we are doing an overview of the law of torts. In our first session, I tried to outline for you where and how tort law fits into the American legal process. It is certainly a very significant area of substantive law for any business, such as a hospitality business, a professional business, a manufacturing business, any business wherein the services or products have a likelihood of, or at least the potential of causing harm to customers and others who use the product or services if the product and services is delivered in a manner that is below that which is legally expected for that producer, that manufacturer, that business, that restaurant. The concept of tort law is really spread out across three different classifications of tort. And we looked at that during our first session where I spoke about intentional wrongdoing, bringing about harm and able to be compensated for those who are the victims of that intentional wrongdoing. We've talked about the fact that the most significant of the subtopics of tort, the subcategories of tort, is the law of negligence, which is the primary focus of this session. And then we'll also talk about issues where we will impose liability without a determination of fault. Generally speaking, when you think of a civil wrong, when you think of a tort, when you think of a negligence action, by way of example, you think of an action wherein those who are harmed as a result of the faulty conduct, the faulty behavior of another who had an obligation to do differently, to do better, to act in a manner that would minimize the likelihood of harm. When that duty, that obligation is breached, the idea of a tort claim is the thought, the notion within law that those whom are harmed have a available avenue towards being compensated for their harm, for their loss. I suggested to you during the first session that tort law is a very subjective concept in that we're judging behavior after that behavior has occurred and after, frankly, we know the outcome of that behavior. It is always tempting, it is always easy to look back at a particular set of facts or circumstances when we know that in the end there was harm, there was injury, there was damage, and want to reason our way to legal culpability. And so there are parameters, there are elements, there are features that must be present for us to find legal culpability, a tort. And in the discussion of this session, negligence. It is not sufficient that my behavior cause you harm. My behavior must be unlawful in causing you harm. And this is a point that I will emphasize more as we move into discussions about business liability or more discussions about business liability. The fact is that if you are a competitor of mine and you are more likable than I, and you produce your product cheaper and faster than I do, and your product is better than mine, well, then your behavior is causing harm to me because people are going to gravitate towards someone who builds a better product, cheaper, faster, and certainly is more likable. But there is nothing unlawful about building a better, cheaper, faster product and being more likable, certainly. So wherein your behavior is harming me because you're better and faster and cheaper and more likable, There's certainly nothing unlawful about your behavior. I wouldn't have the ability to successfully sue you. There would be no basis upon which I would be able to bring a lawsuit, at least a successful lawsuit. There has to be an unlawful act. And in the first session, when we were focusing in on intentional tort, I outlined for you the potential unlawful acts as being examples such as assault and battery and false imprisonment and conversion, any crime to which there is an impact upon a victim or property. And the ability to establish that an intentional tort has been committed really is not any more complicated than looking at the elements of the cause of action, the elements of the tort, and applying those elements to a particular set of facts. Was there a intentional and wrongful touching by one of another? You know, there's a difference, obviously, between accidentally falling into someone and hauling off and punching them. I had a professor of mine in law school that used to always reference the difference between an intentional wrongful act and merely a negligent act. And the example that he would give would be he was a big pet owner. And his example was always that even a dog knows the difference between being kicked and being tripped over. And the example is really the difference between intentional wrongful behavior, the kicking, the punching, if you will, which would give rise to a claim for assault and battery, as opposed to merely running out of space, tripping, falling, and maybe running into someone where that's accidental. It's not certainly going to constitute an assault and battery. And the only way that you're going to have acted unlawfully is if it is shown that you were acting unreasonably, negligently, and you caused harm to the individual who was struck. We'll continue to talk about these concepts, but I wish to highlight for you and illustrate for you that merely because someone has acted wrongfully doesn't necessarily mean that they have committed a tort. And merely because someone's actions have caused harm to another also doesn't necessarily mean that they have committed a tort. The wrongful actions, all right, have to give rise to harm, and particularly if those wrongful actions are accidental, negligent, unreasonable. If those wrongful actions are intentional, we will presume that there was harm, and we will not require the victim of those intentional actions to show objective evidence of harm, that spectrum of fault that we talked about. I am a proponent of using synonyms when discussing or talking about terms of law, particularly terms that many of you may be unfamiliar with. With this session, our focus is negligence. But I think that it's important to break apart the concept of negligence and perhaps explain it as simply being unreasonable behavior. What is it to act lawfully in and under a particular set of circumstances? Well, ask yourself, how would a reasonably prudent person act under the same or similar circumstances? How would a reasonably prudent person act under the same or similar circumstances? In other words, what would a reasonable person do, or what would a reasonable person have to do given a particular set of circumstances? Unlike with intentional torts, when we apply the concept of negligence, we have the potential of looking at almost all type of human behavior and making a determination as to whether or not that behavior was negligent. How would a reasonable or responsible person have acted under the same or similar circumstances? I am carrying a cup of ice water down the hallway at the Epley Center. And perhaps even through no fault of mine, someone bumps my arm and that ice water spills onto the tile floor at the Epley Center. Because of my decision, my choice to go through the Epley Center with ice water, that ice water is now on the floor. And what is the result of that ice water being on the floor? The result of that ice water being on the floor is that potentially anyone else that's coming through the Epley Center at that time or for a reasonable period thereafter is put at risk. Somebody could be walking through the Epley Center, not see that there is water, or certainly see that there is ice on the floor. They could hit that water, they could hit that ice, and they could go flying and they could get injured. So if I am walking through the Epley Center with a cup of ice water, even if it is through no fault of mine, if that ice water ends up on the floor, I now have a obligation. And that obligation would be to take reasonable steps, reasonable efforts to either clean up the ice water or at an absolute minimum to try to warn others that, hey, be careful, there's ice water on the floor. That would be my legal obligation. That would be my legal duty. And if someone were to come upon that ice water and I would not have tried to clean it up or not warn them that there's ice water on the floor, and if they were to happen upon that ice water and fall and be injured, they could sue me for my negligent behavior. My negligent behavior, notably being not cleaning up something that I caused to be on the floor to begin with. And sure, the fact that it might not have been my fault that the water was knocked out of my hand, it was my choice to bring the water onto the floor, and it was my responsibility then to clean up the spill that was caused by my decision to bring the water into the building or onto the floor, into the premises to begin with. What would a reasonable person do when they spill water and ice on the floor? They clean it up. Because if they don't, there should be the recognition that others are now put in harm's way. And we have an obligation, we have a duty, we have a contract, if you will, with society, that when it is our actions, our conduct, our behavior that have the potential of putting others in harm's way, we have an obligation to minimize the likelihood of harm that will be caused to those others. This is a concept very much consistent with the idea of allowing people who are harmed as a result of the negligence of others to be compensated. Now, let's take that ice water example one step further. You, student, are watching me walk through the hallway, beverage in hand. You watch perhaps another student or another faculty member knock that beverage out of my hand and onto the floor below me. You, student, look and observe that there is somebody walking in that direction. Maybe they are elderly, maybe they have a vision impairment. There is someone that is walking right dead smack into the direction of where I have dropped the ice. I would make the argument, I believe, that you would have an ethical obligation, a moral obligation, if you will, to try to stop the person who's about ready to step on the ice cube from doing so. Minimally, I would hope that you would give a shout out, hey, be careful, watch it. But you would actually not be under any legal obligation to act. This is because you in no way, shape, or form actually caused or contributed to the ice and beverage falling upon the floor. Now, again, I believe that one has a moral, ethical obligation to step in and try to help to minimize the likelihood of harm to others. I think most of you would do that. I certainly hope that I would. But that's not the legal requirement. The law doesn't mandate that we get involved in circumstances to which we are not already under a legal obligation or duty to act or engage in. Now, if you are the caretaker for the elderly person, not quite sure what they would have been doing in the Epley Center to begin with, but if you are the caretaker for the person that has the visual impairment, now you would have an affirmative obligation. Now you would have a duty. If you spill a beverage in the Epley Center, and I, as a faculty member, am walking through the Epley Center, and I see another one of the students about to happen upon the ice, I believe that I do have a legal obligation to make whatever efforts there are to minimize the possibility of harm. This concept of legal duty, this concept of legal obligation is significant, and it's something we will go back to. It's something that I have brought up before and will continue to point out. What is the basis upon which our legal obligation is premised? What is the basis upon which our claim that another has acted unlawful is based? How is the law that establishes the legal relationship between parties created? What is it that has created or established the legal obligation? As we have talked about, as you hopefully are really starting to see, those legal obligations are established when we enter into a contract with others, when we have a statute that details how we are to act, and also when it is our behavior, our product, our business, our profession, who we are involved in, has the potential of putting others in harm's way. We then have an obligation, a duty. We have the legal mandate to act with reasonable care for the safety and welfare of those people whom it is our behavior that can cause harm to. A lot of words to really basically describe the concept. When engaged in any activity that has the potential of causing harm to others, take all reasonable steps to minimize the risk of harm to those others. That is the legal obligation. That is, if you will, the contract that we have with society. It is not a mandate. It is not an obligation that we act perfectly. It is certainly a mandate. It is certainly an obligation that we utilize our best efforts. So let's look at the tort of negligence. Let's look at this category of tort law. Unlike crimes that have labels attached to them, names, unlike intentional torts, which, like crimes, have labels and names attached to them, when we apply the tort of negligence, when we apply the elements of negligence to a particular set of facts, we have parameters, we have elements of the concept of negligence that we apply. But it is potential that practically anything that we build, do, or are involved with could give rise to harm to another person or their property. Ergo, that pretty well everything that we do, we have the obligation to utilize reasonable care when partaking and engaging in that behavior. Without question, negligence is the most common type or category of tort that we have. In fact, the concept of negligence is really, in many respects, utilized as a synonym for the whole area of law that we refer to collectively as tort law. When you hear about a tort case, 9 times out of 10, the tort case is going to involve a claim of negligent behavior resulting in harm to someone whom the defendant owed a duty, an obligation to have acted in a particular manner towards or to protect. Intent is not a requirement for the tort of negligence. Fault is synonymous with the idea, the notion of negligent behavior. It is important to recognize that we all from time to time will act negligently. We all from time to time will engage in behavior that is not consistent with our lawful obligations. Fortunately, not all of the time that we act in a negligent manner, we have committed the tort of negligence. Be honest with yourselves. How many of you in the last couple of days, maybe in the last week, when you've driven a car, have had your cell phone somewhere close to you and you've taken a peek at a text or changed music, and you've just taken your eyes off the road for even a split second? We rationalize our behavior. We justify to ourselves our behavior. But the fact of the matter is that when you're taking your eyes off of the road and you are instead focusing your attention on your phone, that is negligent behavior. Now, hopefully for all of you, this has not resulted in committing the tort of negligence, because the tort of negligence only exists where we cause harm to others. And that harm has to be established through some form of objective evidence. There has to be actual evidence that our unreasonable behavior has damaged someone. I had a gentleman that came in to see me some years ago, and he had gone to a restaurant in the community. It was about 4 o'clock in the morning when he went to that restaurant. The restaurant was waxing the entranceway, or employees were waxing the entranceway to the restaurant. There was no signage guarding or warning patrons. And when he walked in the entranceway, he caught a hold of the wax and he went flying, hit his head. And in fact, all of it was captured on video. He sat down with me to discuss filing a tort claim, specifically a negligence claim against the restaurant. We went through all of the elements that comprise the tort of negligence. Did the restaurant owe a legal obligation, what we call a duty, to this man? Absolutely. Did they breach that legal duty to this man? Or in other words, did they act unreasonably? Absolutely. Did their unreasonable behavior cause or result in the fall? You bet. But then I asked him kind of the $64,000 question. What were his injuries? And he smiled and he said to me that he had no injuries. He indicated that he had been drinking quite a bit that evening, and perhaps a result of some luck, even though he went down hard and we could see that on the video, he actually did not get physically injured. No physical injury, then the fact that he might have been embarrassed, the fact that they should have had their premises in a more reasonable condition, meaningless. Because for the restaurant to have acted and committed the tort of negligence, there had to be actual evidence of harm, actual injury that was sustained. Now, you can apply these principles to almost any aspect of human behavior. But to make it easier for us to determine, reach conclusion about whether or not the tort of negligence has been committed, we apply these four elements. And I assure you that any lawyer that you know or any law student whom you know probably at some point in time in their sleep repeats the four elements that make up the tort of negligence. Those four elements are duty, breach of duty, causation, and damage. Duty, breach of duty, causation, and damage. And all four of the elements that make up the tort of negligence must be present at the same time. It is insufficient just simply to act negligently. That's not the tort of negligence. Again, we all from time to time act unreasonably. Fortunately, our unreasonable conduct doesn't result in the tort of negligence unless each of these four elements is present and present at the same time. First, for us to have committed the tort of negligence, for us to be found to act unlawfully towards another, we must have owed a duty to that individual who is claiming that we have acted unlawfully. The first, and in many respects, most significant element in any negligence case is to establish that the defendant owed the plaintiff, the alleged victim, an actual legal duty. What was the legal obligation owed by defendant to plaintiff? If you are the owner of a bar, a restaurant, a business, when you bring people into your establishment, owe those patrons, those customers, the highest duty of care. Those persons who are there to spend money with you or potentially spend money with you are classified under the law as an invitee. And as an invitee, you owe those persons the maximum legal obligation to safeguard their welfare and health. You have to actually look around the premises and not just simply warn them of any known defects, but to actually try to either fix the deficiencies or to keep the patrons from coming close to those deficiencies. We've closed off the stairs because one of the stairs is wobbly or has a hole in it. That's the obligation if a customer is coming into my establishment. It's not sufficient for me just simply to say, don't go over there. I must actually stop them in some manner from going over to a place where they can be hurt. But if you go as a social guest to someone's house, not intending to spend money with them, the obligation that is owed, the duty that is owed, is lesser. We call circumstances when you are going to the residence of another, when you are going to somebody else's property, not to provide them an economic benefit, we call you a licensee. You are to be warned of any deficiencies, but you are not someone who is owed an obligation to have those deficiencies fixed. Of course, if you're on the premises of another without their permission, and you are there wrongfully, you are classified as, you probably know this one, you are classified as someone who is upon the premises of another, excuse me. Excuse me again. I'm going to hit hold as I sneeze more. Sorry about that. When you are on the premises of another person without their permission, you're a trespasser. And what legal duty is owed to a trespasser, as one I think, reasonably assume no legal duty is owed to a trespasser. So the concept of what type of legal duty, what type of obligation is owed, is one to which um, we will spend some time and attention in detail as we look through some cases that I wish to expose you to involving a determination of whether or not behavior constituted negligent behavior. There must be a legal duty, an obligation owed from the alleged wrongdoer to the individual who is claiming that they have been the victim of unlawful or wrongful behavior. Did you owe a duty, an obligation to the person whom you saw about to fall on the ice that I dropped on the floor at the Epley Center? Unless you already had some pre-existing obligation, if you didn't cause the spill, the answer is no. Even though I would argue ethically, morally, you probably ought to step in and try to help. We owe a duty. We owe a responsibility. We owe an obligation to all those whom it is reasonably foreseeable to believe that our unreasonable conduct, our negligent conduct, could cause harm to. A lot of words, but a pretty simple concept. If it is reasonably foreseeable that our unreasonable conduct could cause someone to be harmed, we owe them a legal duty. Those are people that are called to be or understood to be within the zone of danger. Think about all of the things that you could do that could cause harm to others. Whom are the others that your behavior puts at risk? Those are the individuals to whom you owe a duty. Sometimes we will codify the concept of duty. For those, and I discussed this briefly during session 1, who provide alcoholic beverages to others. If you provide an alcoholic beverage to a visibly intoxicated person or to a minor, and that visibly intoxicated person or that minor goes out and injures another person or even themselves, as the provider of that alcohol, you can be held liable. You owe a duty to those whom are harmed when you serve a minor or a visibly intoxicated person alcohol. I have some lecture slides that follow this lecture slide, kind of outlining and explaining each of the various elements in a little bit more detail. I'm not going to go through those lecture slides with you per se, but I want you to understand what each of these elements entails. To whom do we owe a legal duty? To those whom it would be foreseeable that our negligent actions, our unreasonable actions could cause harm to. We don't have to actually be able to see how it is that we would harm them, the extent of the harm that we could cause them. The fact that I'm driving my car and the pedestrian along the side of the road is someone whom clearly I owe a legal duty to. Well, what if I hit the car in front of me and it's the car in front of me that pops up on the curb and hits the pedestrian? I owed the pedestrian a legal duty. The fact that it might not have been actually likely that my hitting the car in front of me would hurt the pedestrian. If I have unlawfully driven my car, if I have negligently driven my car, and when there's a rear end collision, we presume the car in the rear to be at fault. If I am at fault in hitting the car in front of me and causing the car in front of me to go up on the curb and hit the pedestrian can and likely will have a successful claim against me for negligence. The fact that The manner upon which the injury occurred was not the most likely or something that we saw isn't the issue. Was the person foreseeable? At the same time, we have a rule of law as it relates to duty that is known as, and I'm not making this up, the eggshell skulled plaintiff rule. In the eggshell skulled plaintiff rule, to which there is a lecture slide explaining, the eggshell skulled plaintiff rule is the rule of negligence that you take your victim in a negligence case as you find them. The fact that I engage in behavior that would not have resulted in 99.9% of the population getting injured, but I happen to engage in behavior that results in the 0.1% of the population that does get injured, the eggshell skulled plaintiff, if you will. I take my victim as I find them. I am responsible for all of the injuries sustained by anyone who is in the zone of danger, anyone whom it is reasonably foreseeable that my unreasonable actions could cause harm to. I am on the hook for the full extent of the injuries that my bad behavior has caused them. The second element in the tort of negligence is that the tortfeasor, the alleged wrongdoer, breached their legal obligation, breached their duty. This is a question of fact. We ask juries to determine what is and what is not reasonable behavior. The concept of to whom a duty is owed and what that duty is generally a question of law for the court, for the judge to decide. But whether that duty is breached, whether there was unreasonable behavior, what was expected of the defendant, how did that conduct of the defendant dip below that which was expected of him or her or it? That, the question of breach of duty, is something that we put to juries. There has to be a cause and effect relationship between the unreasonable behavior and the resultant harm. This is the element known as causation. And while I won't hold you accountable for the different ways that we view causation, there's two parts to causation, what we call actual cause and proximate cause or legal cause. I think it is important to understand that there absolutely has to be a cause and effect relationship between the unreasonable behavior and the resultant harm. I will give you an example. And I will actually give you an example of a case that I won. Shouldn't have, but did. And I prefaced the example by telling you, as I did during session one, I have lost trials. But this was one that actually I happened to win. I was representing a restaurant out of the community. And it was a case in which the patron of the restaurant was cutting through the driveway of the restaurant and collided with a delivery truck at an intersection in the parking lot. It was actually somewhat of what we call a blind intersection, in as much it was very difficult to see around the corner of the building. And the designer of the parking lot had put up stop signs at the intersection. And over the course of years, my client had not replaced the stop signs. So one could very well say my client was at fault. And in fact, show you what a brilliant legal mind I am. I actually asked my client for the ability to admit fault because there should have been stop signs in the parking lot. There weren't stop signs in the parking lot. The parking lot called for stop signs to be in the parking lot, and that was on us. But there was three parties to the litigation because the driver of the car sued not just the owner of the restaurant, the operator of the parking lot, but also the driver of the delivery truck. And there was clearly a fairly high speed impact between the delivery truck and the driver of the vehicle. And the driver of the delivery truck pointed the finger at the driver of the car, the plaintiff, who was suing us, and said she was driving way too fast. And the driver of the car, who was suing the truck driver and the operator of the restaurant, my client, was pointing the finger at the truck driver and saying, no, it was the truck driver that was driving way too fast. So they were pointing fingers at each other, and I was sitting back expecting we're going to lose. But then the driver of the truck took the witness stand and pointed the finger and said the driver of the car was driving way too fast. And the driver of the car took the witness stand and pointed to the truck driver and said the driver of the truck was driving way too fast. And I stood up finally to cross-examine the driver of the car. And I asked probably the most ridiculous question I have ever asked in court. I remember it well. I walked over to the stand, and on my way over to the stand, I was thinking to myself, what in the world am I going to ask? We're going to lose. But I had to ask something. And I asked the young lady what she would have done differently had there been a stop sign at the corner where the accident took place. And as I asked that question, what would you have done differently had there been a stop sign there? I heard those words coming out of my mouth, and I actually thought to myself, I must be the worst lawyer that's ever practiced. Because this is such an unbelievably simple question to answer. But her answer, I will never forget. She looked at me and she said, well, I wouldn't have done anything differently had there been a stop sign there, because I proceeded as if there was a stop sign in the parking lot. As bad as my question was, I remember having at least the presence of mind of thinking, say nothing more. I sat down. We were out. The plaintiff had been so bothered by the testimony of the truck driver that she actually was willing to not tell the truth, and not tell the truth to her own detriment. Look at the elements of negligence. Did the owner and operator of the parking lot owe this young woman a legal duty? Absolutely. She was a patron of the restaurant. What was that legal duty? Have a stop sign up in the parking lot where an accident can and did take place. There was no stop sign. That is a clear breach of the legal obligation, the legal duty owed to that young woman and all other drivers in that parking lot. And was there harm? Was there damage done? There was impact. There was damage. It was a pretty significant crash. But look at that third element, causation. If, as her testimony went in, were true, and I was willing to believe it, believe me, that she acted as if there was a stop sign in the parking lot, then how was it that not having a stop sign there caused the accident? Now, clearly she was not telling the truth, but I was more than willing in that circumstance to accept her version of the facts, because her version of the facts established duty, breach of duty, and damage, but no causation. All four elements must be present, and they must be present at the same time for the tort of negligence to exist. Again, I've lost my share of cases. It's always fun to think back on the ones that you've won. Negligence is conduct which falls below the acceptable legal standard that exists for the protection of others against unreasonable risk of harm. We utilize an objective test. The concept of negligence is quite subjective, but we employ this objective test, comparing the actions of this defendant to those which we would have expected of a reasonable person under the same or similar circumstances. Again, what would a reasonably prudent person do under these or similar circumstances? That's what we expect. And if a defendant is able to show, or better yet, if a plaintiff is unable to show, because it's the plaintiff that bears the burden of persuasion on each of these elements. If a plaintiff is unable to show how the defendant acted in a way that is different than how a reasonably prudent person would have acted under the same or similar circumstances, then the plaintiff's going to lose. Because that's the test, that's the standard. When the plaintiffs collectively pointed the finger at Purdue Pharma or Johnson & Johnson or any other defendant in any other tort action, negligence particularly, the obligation upon the plaintiff's attorneys to show how those defendants acted in a manner that was unreasonable and how that unreasonable conduct resulted in an outcome that would have been done and would have been different, had the behavior been as it should have been, actual objective evidence of harm. Now, what I'd like you to do is certainly look through the lecture slides explaining each of the elements in greater detail. There are some other aspects of negligence that I think are worth pointing out. Legally, in most jurisdictions, persons that are under the age of 7 are incapable of acting negligently. When you have a professional person, we hold that professional person to the standard of those within that profession. And obviously, we judge behavior differently depending upon when and how and where that behavior has occurred. By way of example, if you follow the tracking of medical data and statistics, you know that the reasonableness of a response time to a cardiac emergency differs if the response is in New York City as opposed to rural Montana. We expect that the 911 call is going to be responded to and ultimately the patient on the surgical table, if necessary, in a much quicker time frame if the event has occurred in Boston as opposed to South Dakota, rural South Dakota. The concept of professional negligence is referred to as malpractice. Negligence in the manufacturing or design of a product is known as product liability. Again, concepts that we will talk about as we move forward. Look through the lecture slides. I lay out for you the explanation of each of the different elements of negligence. Certainly, you will want to make sure that you understand these explanations, and please feel free to ask me any questions that you might have about the application of these elements. Now, where we will turn next, where we will look at in Torts 3, is some of the defenses that apply to negligence. And we'll look at some facts and circumstances that are perhaps not completely unlike my example of the case I won. I'll probably present to you maybe a case or two that I lost, and where, particularly in defense, each of the elements had been established by a preponderance of the evidence, resulting in a verdict against my client. Trying, as I will, to keep these sessions reasonable and manageable. If you recognize that negligence exists when you're able to establish the 4 elements of duty, breach of duty, causation, damage. Say it with me. Duty, breach of duty, causation, damage. You're a long way towards being able to apply and understand this most subjective area of law, frankly, that we cover. And you're going to be able to have success when presented with similar types of fact patterns on the next exam. Reach out to me if there's anything that I can do or assist you with. We have much more to cover in this substantive area of law known as torts, but nothing more important than understanding the concept, as fluid and evolving as it is, of the law of negligence, and recognizing that negligence is something that differs from one state to another, as this is a substantive area of civil law, primarily established in the form of the common law, judge-made law. Be well, look after yourselves, particularly as we get closer to the midway portion of the semester. Don't neglect your mental health as well as your physical health. Get sufficient sleep, and don't hesitate to reach out to any of us at the university who can help you